Hello, everyone. Welcome to another program here at the Berkeley Center for Law and Technology. This is our expert series webcast, and today we have the Trademark and Brand Protection Year in Review. We have two very, very seasoned trademark practitioners with us, both with extensive trademark and copyright litigation experience and brand protection for, if I went through the list, a whole list of companies that you would recognize. So I'm excited to have our two guests with us. So let me introduce them. Carrie from the LA office of Kilpatrick. She is a partner there. And then Olivia Poppens, some of you may have seen before, Berkeley law grad, so she gets that accolade always. Also there in the LA area for Kilpatrick. So I want to thank both of you for joining us. I know these kinds of programs require some hours and some volunteer time. Berkeley thanks you, and our listeners thank you.
Thanks, Wayne. We are very excited to be here today. As Wayne mentioned, I am a partner in our Los Angeles office. My practice focuses primarily on trademark and copyright enforcement litigation. And I'll let Olivia talk a little bit about herself.
Thanks, Carrie. Yeah, I'm Olivia Poppens-Schultz. I'm a senior associate in our Los Angeles office. And like Carrie, my practice also focuses on trademark and copyright enforcement and disputes work. And we're very, very excited to be here today.
So before we kick it off, we thought we would just go through a little roadmap of what we're going to be discussing today. So we're going to be talking about recent updates in trademark law that are going to cover areas including use in commerce and distinctiveness of word marks, functionality and distinctiveness of trade dress, proving dilution of trade dress, court intervention in the trademark application process, liability for counterfeiting and cybersquatting, trademark damages, and defenses to trademark claims. And that takes us to our first case, which I'm going to cover. This case addresses the issues of use in commerce and distinctiveness of word marks. The plaintiff in this case, Appliance Liquidation Outlet, or ALO, was a decades-old appliance store located in San Antonio, Texas. They filed a trademark infringement action against a company called Access Supply Corporation, which owned and operated an appliance store also in San Antonio called Appliance Liquidation. So the image on the left side of the screen is Appliance Liquidation Outlet storefront, and the image on the right is Appliance Liquidation storefront. As you can see, they look pretty similar. So ALO took issue with the fact that very shortly after Appliance Liquidation opened, there was a large influx of customers that were confused about which company operated which store. ALO did not have a registered mark in the trademark Appliance Liquidation Outlet mark. They had a long history of engaging in a whole bunch of promotional activities to raise brand recognition, like partnering with local sports teams and hosting antique exhibitions and car shows. So as a result, ALO argued that it had valid rights in the Appliance Liquidation Outlet mark, as well as the Appliance Liquidation mark. Access responded by arguing that it was just using the Appliance Liquidation name to describe the fact that its store sold discount appliances. After a bench trial, the district court found in favor of ALO, holding that Access had infringed both the Appliance Liquidation Outlet and the Appliance Liquidation mark. Access appealed. The Fifth Circuit affirmed as to the finding of infringement on the Appliance Liquidation Outlet mark, but they reversed and found that the district court erred with respect to a finding that the Appliance Liquidation mark was valid and could be infringed. So taking a step back, to qualify as a valid trademark, a word, phrase, or symbol has to identify and distinguish the goods and services of one seller from those of others. So in other words, it has to convey to consumers that the trademark owner is the source of the goods and services it offers, and the trademark owner has to use it in that way. As to trademark validity, one of the benefits of owning a trademark registration is that it entitles the trademark holder to a presumption that the mark is valid. And with respect to the validity of ALO's alleged appliance liquidation mark, the Fifth Circuit made note of the fact that there was no registration, so that they were not entitled to the presumption of validity. And the court found that the testimony in the record just didn't support a finding that ALO owned rights in the appliance liquidation mark. and the evidence in the record was slim. There was testimony by one employee that she told people that she worked at appliance liquidation, and that she answered the phone using either appliance liquidation outlet or appliance liquidation. And then there was testimony by ALO's owner, who said that they had ads that would either say appliance liquidation or appliance liquidation outlet. The court found that the testimony at most indicated that appliance liquidation was really more of a shorthand for the real mark, which was appliance liquidation outlet, and that there wasn't any evidence that ALO intentionally used the appliance liquidation name to identify the source of its store. So the lesson in this case is that if you want to claim rights in a mark, you need to very clearly and intentionally use it publicly to identify that you're the source of whatever business you're operating or goods that you're selling. And that takes us to our next case, which talks about functionality and distinctiveness in the context of product design trade dress. So the plaintiff in this case was TBL Licensing. They are the maker of the well-known Timberland boot. I'm sure lots of you have seen them before. TBL filed an application to register the trade dress and the design of the boot. But the kicker is that they didn't seek to register the design of the boot as a whole, probably because they were trying to avoid a finding of functionality or distinctiveness, because you can't get a registration for trade dress if the trade dress is functional or if it's not distinctive. So TBL sought to register just a very specific subset of design features of the boot. I'm going to walk through them. The images on the bottom of the slide are the images that TBL submitted when they sought to register the trade dress. The images are numbered, so it's hopefully a little easier to follow along. The first element was a tube-shaped ankle collar on the outside of the boot, at the top of the boot. Number 2 is a bottom soles with 2 color tones that are divided horizontally and 2 tooth-shaped cutouts. Number 3 is on the back of the boot, an hourglass-shaped rear heel panel that's outlined by quad stitching. Number 4 is quad stitching forming an inverted U at the bottom of the tongue and then going around both sides of the boot. And number 5 was hexagon-shaped eyelets where the shoelaces go through the boot. So ultimately, the USPTO refused to register the trade dress design on the grounds of lack of distinctiveness. So TBL tried to get a second bite at the apple, and they filed suit in federal district court in the Eastern District of Virginia against the USPTO. That did not work because the district court upheld the refusal to register both on distinctiveness grounds and on functionality grounds. So TBL applied to the Fourth Circuit, and that did not work either because the Fourth Circuit upheld the district court's finding of both functionality and lack of distinctiveness. So as to functionality, there were a couple of types of evidence that really did it in for TBL that supported 2 elements of functionality. The first was the existence of at least one utility patent that was obtained by TBL that disclosed every single design element that they were seeking to get trade dress protection for. And the reason for that is because a utility patent by design admits the functionality of whatever you're seeking to get the utility patent for. And the second was evidence of a bunch of ads that were put out by TBL that actually touted the functional benefits of the design elements they were seeking protection for. So neither of those things is good if you're trying to argue lack of functionality. As to distinctiveness, the Fourth Circuit really keyed in on really the most important factor in the case, which was that TBL didn't seek to register the design of the boot as a whole for trade dress protection. They were trying to limit it to just the specific design elements, which meant that it was TBL's burden to prove that it was those elements that were distinctive in the eyes of consumers. And ultimately, it was that kind of position and tactic that doomed TBL with respect to the distinctiveness claim. In terms of the evidence that TBL submitted, they did have a distinctiveness survey, but the district court rejected it and refused to consider it for reasons I'm not going to cover here. We only have so much time today, but I am going to talk about kind of the circumstantial evidence that was left for TBL to rely on to prove distinctiveness, which the district court found insufficient and the Court of Appeal upheld. So the first was advertising expenditures. TBL submitted evidence that it spent over $81 million marketing the boots in the US in the 6 years preceding the suit. But the district court found that that evidence wasn't entitled to very much weight because TBL didn't introduce any evidence that that spend actually translated into an association by consumers of the specific design elements that TBL was seeking protection for with TBL. So what would have been evidence that would have shown that would have been look for advertising. So if TBL would have had ads that said, hey, look for the hexagon shoelace holes and you'll know that these are the Timberland boots. But none of the ads that they submitted supported that. So the Fourth Circuit found that the district court didn't err in looking behind the numbers at the content of the ads that were submitted. As to sales, TBL submitted evidence that it averaged over $100 million in sales per year of the Timberland boots. Again, the district court did not lend that evidence much weight because TBL didn't submit any evidence to show that the sales numbers or their customers were buying the boots because they were associating those specific design elements with TBL. Fourth Circuit found that was not error. The next bucket of evidence was unsolicited media coverage. As the Fourth Circuit noted, TBL submitted a ream of Instagram posts showing that people were posting about the Timberland boots, featuring images of the Timberland boots, that there was all kinds of other media articles featuring the boots, but they didn't show that the media coverage was highlighting the specific design elements of the boots. And in fact, the Fourth Circuit panel said that in most of the evidence of unsolicited media coverage that was submitted, the design features were actually imperceptible in the images. So Fourth Circuit obviously again sided with the district court, finding no error in not considering that evidence as supporting distinctiveness. As to the last couple of buckets of evidence and elements of distinctiveness, for attempts to plagiarize the mark, TBL submitted evidence of a whole bunch of other numerous lookalikes out on the market, but the court found that there was no evidence to show that competitors were copying the specific design elements to try to create confusion and make consumers think that they're infringing boots with the Timberland boots, which is what would make attempts to plagiarize relevant to a finding of distinctiveness. Instead, the court found that the existence of so many lookalikes actually cut against TBL's position that it engaged in continuous and exclusive use of the mark or of the trade dress, because a bunch of other people are using the design, then how can you argue that it's being exclusively used by you? So kind of the takeaway and the moral of the story here is that if you want to try to seek trade dress protection of a design, you need to make sure that your marketing and advertising is specifically pointing out the design elements that you want to seek protection for, and telling consumers to look for those design elements and associate them with you. And that takes us to the next case, which also involves trade dress, except this case went all the way to trial. The plaintiff in this case was Diageo North America, Inc. They're the maker of the Bulleit brand of whiskey. And they filed suit against Deutsch & Sons, which is the maker of the Redemption brand of whiskey. Diageo alleged that Deutsch's Redemption bottle, which is pictured on the right side of the slide, infringed Diageo's trade dress, and the Bulleit bottle, which is pictured on the left. The case made it to trial. The jury found against Diageo on its infringement claims. So it didn't find that consumers were likely to be confused, but they did find in favor of Diageo on its dilution claims. And that's both federal and state dilution claims. As to a claim for federal dilution, a plaintiff has to prove that its marker trade dress is famous, which means widely recognized by the general consuming public. So factors that are taken into consideration in proving fame for purposes of distinctiveness are the duration, extent, and geographic reach of advertising of the trade dress, sales volume and geographic distribution of goods bearing the trade dress, public recognition of the trade dress through things like consumer surveys and media exposure, and then a registration of the trade dress with the USPTO. For purposes of succeeding on the New York state law claim for dilution, plaintiff has to prove that the defendant's trade dress is very similar or substantially similar to the plaintiff's trade dress. And the jury found that Diageo had presented sufficient evidence of both fame and substantial similarity, The Second Circuit agreed with the jury and found that there was sufficient evidence on both points. As to fame, the Second Circuit found that there was lots of evidence to support that. They noted that Diageo had marketed Bulleit bourbon featuring the Bulleit bottle since 1999, that between 2011 and 2016, Diageo spent $56 million on advertising and promotion of the Bulleit bourbon, and those advertisements featured the Bulleit bottle. Between 2005 and 2016, the bullet bottle was featured in at least 16 television shows and 4 movies. Beginning in 2012, the bullet bottle was featured in major magazines like GQ and Esquire. From 2014 to November 2016, Diageo made over $100 million in sales of the bullet bottle. And the bullet trade dress had been registered with the USPTO since 2006. So that's a lot of evidence. Might have sounded a little similar to some of the evidence that TBL tried to submit. I think the difference here, aside from the fact that we're talking about fame versus distinctiveness, is that Diageo was seeking protection for the trade dress in the whole appearance of the bottle, and that's what they submitted evidence of. The Second Circuit also found that there was sufficient evidence to prove substantial similarity between the 2 bottles, and that included a side-by-side comparison of the bullet bottle and the redemption bottle on the shelves in the marketplace. There was also evidence, and this is not good, that Deutsch had revised a design brief that was prepared by one of its design vendors with instructions to propose a new bottle shape that was more similar to the bullet bottle. And there were also market research videos where participants said that the redemption bottle, quote, looked like the bullet bottle, or that it was, quote, just trying to be the bullet rye bottle. So this decision not only clarifies that the claim of dilution applies to trade dress design, but it also provides some helpful guideposts about the types of evidence that plaintiffs can use to succeed in proving fame and substantial similarity for purposes of dilution. And on to our next case, we're moving away from trade dress and into the area of court intervention in the trademark process. So the plaintiff in this case, BBK Tobacco, sold raw branded smoking products like the cigarette rolling papers that are pictured at the bottom of the slide. And the defendant, Central Coast, sold raw garden branded cannabis products like the pre-rolled cannabis joints that are pictured at the top of the slide. BBK sued Central Coast for trademark infringement and also for invalidation of several of Central Coast's trademark applications for the raw mark. The district court granted summary judgment in favor of BBK on its trademark invalidation claims, finding that Central Coast lacked a bona fide intent to use the mark with a bunch of the goods that it sought registration for, which is required under the Lanham Act. Not surprisingly, Central Coast appealed, but what is surprising is that they did not appeal the finding of lack of bona fide intent to use. What they did appeal was that the district court had jurisdiction to void the trademark applications in the first place because they were taking the position that district courts only have authority to cancel a registration and not to invalidate an application. So one of the sections of the Lanham Act that's at issue here is Section 1119, and that provides in pertinent part that in any action involving a registered mark, the court may determine the right to registration and otherwise rectify the register with respect to registrations of any party to the action. The bolded language is important because that's what the court was relying on ultimately. And Section 1051 of the Act codifies the intent to use requirement for applications, which says that anyone who has a bona fide intent to use a mark in commerce can request registration of the mark on the principal register. So the question of whether a court has authority to invalidate a trademark registration to invalidate a trademark application as opposed to canceling a trademark registration was a question of first impression for the Ninth Circuit. In a 2-1 split decision, the majority held that the plain language of Section 1119 does grant a district court jurisdiction to consider challenges to an application. And the majority's reasoning was this: a district court's authority to, quote, determine the right to registration and to, quote, rectify the register includes the power to decide disputes over trademark applications. It must, right? Because the Lanham Act refers to an application for use of a trademark as a request for registration of a trademark on the principal register. So as a result, according to the majority, a challenge to an application then necessarily affects the applicant's right to registration. So that's a broad interpretation of Section 1119. The dissent took a different position, that the statute only grants the power over completed registrations. And the argument there is that allowing that type of judicial intervention in the trademark application process improperly disrupts the USPTO's administrative application review process, which is pretty iterative. Oftentimes you have trademark applicants going back and forth with the trademark examining attorney. And then applicants also have the chance to appeal decisions of refusal to register to the Trademark Trial and Appeal Board. So ultimately, the practical consequence of this decision is that holders of trademark registrations in the Ninth Circuit can now challenge a competitor's pending applications in district court, as opposed to just being limited to an opposition proceeding before the TTAB. It can also impact cannabis businesses who often file intent to use applications, waiting for a time when they're, maybe hopefully able to register if cannabis is ever legalized federally. And that takes us to our next case, which is an interesting one. It got a lot of press over the last year. There were lots of decisions, including on motions for summary judgment. And then most recently at trial in November, when the jury found in favor of Penn State against the defendant Vintage Brands. I think one of the more interesting aspects of this case is the decision on Penn State's counterfeiting claim, which was decided on summary judgment, which I'll talk about in a minute. But as a little bit of background, Penn State, not surprisingly, as a university, they have a licensing program like lots of universities do, where they license their marks for others to use in the sale of merchandise. And that was under a variety of marks that are pictured here: the S Lion logo, the Penn State seal, the Pozniak Lion Head logo, and the Nittany Lion logos. And Vintage Brand is a company that sells, surprise, vintage style merchandise featuring old logos of universities and various professional sports teams. So the interesting thing is that Vintage Brand gets their logos from a pretty large collection of sports memorabilia that it owns, and they scan and reproduce the images of the logos and then put those logos on various items of merchandise that people purchase from the Vintage Brands website. So before the lawsuit was filed, Vintage Brands had a whole page dedicated to Penn State where people could buy Penn State branded merchandise. And some examples here, t-shirts, cups, cutting boards, you name it, you could buy it. So Penn State obviously was not happy about this. They sued Vintage Brands for all the trademark claims: willful trademark infringement, counterfeiting, unfair competition, and false designation of origin, false advertising, dilution. If there was a trademark claim that existed, they filed suit for it. As to the counterfeiting claim, so Vintage Brands moved for summary judgment, arguing that the images on its goods were not substantially substantially indistinguishable from Penn State's marks. That's required under the Lanham Act to prove counterfeiting, because Vintage Brands' own mark was not only very prominent on its website, but it also placed its mark on the packaging for the products it sold. So the Lanham Act defines a counterfeit as a spurious mark which is identical with or substantially indistinguishable from a registered mark. Although spurious isn't defined specifically under the Lanham Act, courts have defined it as deceptively suggesting an erroneous origin or fake. In practice, courts have typically found that counterfeiting only occurs where a substantially identical mark is used to pass off somebody else's product as the original. So like an identical knockoff, in other words. So counterfeiting then does not apply when an infringer is just placing an infringing mark on a good that is going to create confusion among consumers about the sponsorship or authorization by the trademark owner of that good. So here the district court found that Penn State didn't present any evidence that consumers were likely to be confused into thinking that Vintage Brands was selling goods made by Penn State. And that was for a couple of different reasons. The court found that it's nearly impossible to think that any rational consumer, and these were the court's words, would expect a university to produce its own merchandise and therefore be confused as to the origin of the goods that Vintage Brands was selling. The court also found that the Vintage Brands mark, as I said earlier, appears on the top of its webpage and on all of its packaging, which would make it implausible that a consumer would think that the goods that Vintage Brands was selling were goods that were made by Penn State. So this holding is a good cautionary tale that there are guardrails that exist around counterfeiting claims. They're really kind of reserved to situations where someone is creating an identical knockoff of someone else's product and trying to sell the knockoff as the product of the original trademark holder. And that brings us to our next case and the last case I'm going to be talking about today, which deals with the issue of liability for cybersquatting. So the plaintiff in this case was a social justice organization. They were known as Campaign Zero, and they were focused on eliminating police violence. The defendant in the case was a guy named Samuel Sinyangwe. He was one of the original co-founders of Campaign Zero. And he was a Stanford-trained data scientist and policy analyst who created a project called Mapping Police Violence, or MPV, as I will refer to it. So he created that project in 2015. MPV was basically a database that he created to track and analyze police violence across the country. He launched a website for MPV on March 1st, 2015 through a platform called Squarespace. And the site contained an interactive map where people could track incidences of police violence all over the country. That map is pictured on the top image in the slide here. That same day in March, one of Mr. Sinyangwe's Campaign Zero co-founders registered the domain mappingpoliceviolence.org, which redirected to Mr. Sinyangwe's MPV website. In the years after Mr. Sinyangwe continued to work on his MPV project, he updated the underlying data compilations and made various improvements to the website. The website actually gained some prominence, and people came to view it as a pretty reliable source of data on incidences of police violence, and it was cited in major news articles and studies all over the country. So Mr. Sinyangwe then ended up having a falling out with his co-founders and Campaign Zero after they launched a social media campaign that he did not agree with after the killing of George Floyd, and eventually they parted ways in September 2021. Shortly after that, Mr. Sinyangwe started a competing nonprofit called Mapping Police Violence, Inc. Not surprisingly, Campaign Zero was not happy with that. So one of their representatives tried to contract Squarespace to see if they could get the credentials to Mr. Sinyangwe's Squarespace account and take control of the MPV website. That did not work, so Campaign Zero then launched essentially a copycat website of the MPV website on mappingpoliceviolence.org, and that's pictured at the bottom of the slide here. So after some ensuing unpleasantries, Campaign Zero eventually filed suit against Mr. Sinyangwe. He counterclaimed for, among other things, a violation of the Anti-Cybersquatting Consumer Protection Act, or the ACPA, and that was based on Campaign Zero's launch of the copycat MPV website on the mappingpoliceviolence.org domain. So the elements of an ACPA claim are, number one and most important, that the claimant's mark was distinctive at the time of registration of the domain. Number two, that the infringing domain name is identical or confusingly similar to the complainant's mark. And number three is that the infringer has a bad faith intent to profit from the mark. So here, Campaign Zero moved to dismiss the ACPA claim on the ground that it initially registered the mappingpoliceviolence.org domain in March 2015, which was at the exact same time that the MPV project was launched by Mr. Sinyangwe. So the Mapping Police Violence mark, couldn't have gained distinctiveness if the domain was registered simultaneously with the first use of the mark. Mr. Sinyangwe, in response, argued that the Mapping Police Violence mark had, at a minimum, acquired distinctiveness between March 2015 and September 2021, when he parted ways with Campaign Zero, and that Campaign Zero renewed the registration of the mappingpoliceviolence.org domain in 2023, which would thereby satisfy the ACPA's first element that the Mapping Police Violence mark was distinctive at the time of registration, because Mr. Sinyangwe was arguing that registration means either initial registration of a domain or re-registration by way of renewal. And the district court agreed with Mr. Sinyangwe. It joined federal appellate courts in the 3rd, 4th, and 11th circuits, holding that registration for purposes of an ACPA claim applies to both initial registration and re-registration through renewal. And on that basis, the court denied Campaign Zero's motion to dismiss the ACPA claim. So this is a lesson to choose your jurisdiction wisely if you want to file an ACPA claim against someone who's owned a domain since before you acquired rights in the mark that you are seeking to base your ACPA claim on. And that is it for me today. I'm going to hand the reins over to Olivia now to talk about her cases.
Wonderful. Thanks so much, Carrie. All right, so we're going to move on now to damages and defenses, and we're going to start here with a 2023 case that was recently granted cert by the Supreme Court called Dewberry Engineers versus Dewberry Group. And this case has been pretty high on the radar. It has some interesting ramifications for the scope of damages by named parties and unnamed parties. This case involves a Northern Virginia-based civil engineering and surveying firm that expanded into real estate development and architecture called Dewberry Engineers against an Atlanta-based company called Dewberry Group, which similarly provided real estate services. Without going through the likelihood of confusion analysis, I think we can all agree that these names are very similar. So for purposes of this section, I'm just going to call the parties plaintiff and defendant. For some background here, the parties had been in dispute for quite some time prior to this action, and had actually signed a settlement agreement in 2007 that did allow a defendant to use its mark, subject to some certain restrictions. Defendant could only use its column logo, which is not the logo shown on the slide, could not use the term Dewberry for its services in Virginia, DC, or Maryland, and could not use Dewberry for architectural or engineering services. The breakdown of this agreement, or perhaps the suppression of the agreement by the owner from the GC of the company, led to the present dispute. Back in 2023, the Fourth Circuit affirmed a massive accounting of profits by a North Carolina federal district court to the tune of over $40 million in damages against defendant. Plaintiff targeted only a single defendant in its complaint, Dewberry Group, but the Court of Appeals affirmed an accounting that considered the profits of not only the named defendant, but several affiliates of defendant, without actually ordering those affiliates to disgorge their profits by piercing the corporate veil, as is traditionally done. Addressing the question of plaintiff's entitlement to the disgorgement of profits, the court looked at a 6-factor test. The first factor was whether the defendant had the intent to confuse or deceive. The second, whether sales have been diverted. The third, the adequacy of other remedies. 4, any unreasonable delay by the plaintiff in asserting its rights. 5, the public interest in making the misconduct unprofitable. And 6, whether it was a case of palming off. So there was no dispute in the appellate record that the defendant's infringement had not resulted in diverted sales, and defendant had not passed off any of its services as those of plaintiff. That said, the defendant had ignored several red flags cautioning against its conduct, including numerous demand letters from the plaintiff, the USPTO's rejection of the Dewberry Group mark, and perhaps most damning here was its own admission in earlier negotiations that the marks were confusingly similar. Beyond that, there was also considerable evidence and testimony regarding the damage caused to plaintiff's brand equity by defendant's infringement, including details about the state of defendant's properties. I will spare you all the gory details, but it involved so many rats. As for the actual accounting, the defendant argued it did not actually provide services under its infringing mark to other groups for a profit. Instead, it produced infringing branding for its affiliates as a real estate group, and those affiliates then generated profits using that branding on their lease, loan, and other promotional materials. Defendant's tax returns actually showed that it operated at a loss. The distinction between the defendant and its affiliates did not sway the court here, though, which focused on the fact that the defendant and its affiliates were ultimately owned by the same individual who, like the defendant's affiliates, was not named in this action. Although the plaintiff had apparently made no effort to pierce the corporate veil here between the defendant and its affiliates, the court held that the equitable nature of the accounting remedy obviated the need for such a nicety. A district court's grant of profit disgorgement is subject to the principles of equity and is ultimately a matter for the court's discretion. And as we can see, they really took their discretion here. So the court then reviewed the actual quantum of the accounting ordered by the district court. Defendant naturally did not anticipate that it would be required to disgorge profits of its non-party affiliates, and the defendant did not introduce testimony or evidence of those companies' deductible costs. So without that testimony, the district court used plaintiff's expert witnesses' testimony to discount the affiliate's revenues by 20% to account for revenue that may not have had any relation to the infringing activities. The defendant naturally objected to that as speculative, but the appeals court held that any arbitrariness could be traced back to defendant's strategy of denying connection between its affiliates' revenues and its infringing marks. The defendant did not offer any calculations for its costs, nor did it provide any calculations that distinguished between the infringing and non-infringing revenues, and the court found that that was defendant's burden. So ultimately, defendant was slapped with disgorgement to the tune of $42.9 million, enforceable only against the single named defendant. A pretty incredible outcome. So the Supreme Court has granted review and will determine which party here is asking the correct question. The defendant is asking whether an award of the defendant's profits under Section 35A of the Lanham Act can include an order for the defendant to disgorge the distinct profits of legally separate non-party corporate affiliates. Plaintiff, on the other side, however, believes that the court should consider whether a district court's discretion under the Lanham Act permits using the financial statement of non-arm's length affiliates to adjust a disgorgement of profit award against a trademark infringer, and only that infringer, when the infringer has claimed $0 in profits. So this case could have some really interesting impacts on damages calculations going forward, and could kind of shake up the idea of corporate separateness as we know it. We'll look forward to updates on this case in coming months, and I think it's one we'll all really have our eyes on. All right, so this takes us next to an interesting case on the territorial limits of the Lanham Act and how damages are accounted in the wake of a recent Supreme Court decision. In 2023, the Supreme Court adopted a restrictive rule governing extraterritorial applications of the Federal Lanham Act in Abitron v. Hetronic. That holding had potentially significant consequences on remand to the prevailing plaintiff's request for an accounting of damages. The Supreme Court's opinion in that case rejected the prevailing view among the Federal Circuit Courts of Appeals that the Lanham Act's text rebuts the general presumption against extraterritorial applications of federal law. Instead, it applied a two-step test consistent with the one it had applied in other contexts to hold that 1, Congress did not affirmatively and unmistakably provide that the act applies to foreign conduct, and 2, the focus of at least some of the alleged infringement in the case may not have been in the United States. The court ultimately held that the provisions are not extraterritorial, but that they remain in force when a foreign entity uses an infringing mark in domestic commerce. So with this decision, the 10th Circuit then held on remand, the plain focus of Section 32A1 and Section 43A1 is to punish unauthorized commercial uses of U.S. registered trademarks that harm American business and consumers by causing confusion about the true origin of a product. So you can see a very heavy emphasis on U.S. and American here. The 10th Circuit looked at which of the defendant's infringing activities amounted to an infringing use, and then looked at the actual location where that infringement occurred. Here, the court addressed the defendant's sales to purchasers in the United States and their activities in the U.S. on one hand, and then on the other hand, their sales to purchasers outside the United States. So for sales made within the U.S., this decision was quite straightforward. For sales of products blatantly using plaintiff's trademarks, shown on the right, in the U.S., no extraterritorial application of the Lanham Act is required, and the Lanham Act applies because the sale used plaintiff's trademarks in domestic commerce in a way that threatened confusion among U.S. consumers. The court reached the same conclusion with respect to activities of the distributor of defendant's goods in the United States, because use in commerce includes marketing, advertising, and distributing. The analysis changed, however, with respect to defendant's sales of offending goods in Europe that wound up in the U.S. through downstream sales. Although the plaintiff argued that those sales were actionable because the defendants intended them to be resold in the U.S., the court held instead that products bound for the United States but sold abroad are not actionable under the Lanham Act without some domestic conduct tying the sales to an infringing use of the mark in the U.S. Defendants were then only responsible for the U.S.-based conduct, and their disgorgement of profits was then limited to the U.S. in that regard. So this is one of those first cases showing us how the Supreme Court's ruling will apply, and it's useful to guide future damages considerations in cases with extraterritorial issues. All right, so now we're going to turn over to to defenses. So when I gave this presentation in 2023, the main focus was VIP products, be Jack Daniels, and how that had shaken up the Rogers defense. So now 2 years later, we're still looking at cases and how they're evaluated in its wake. And one of those cases is Punchbowl v. AJ Press. This was decided in the 9th Circuit last year. As many of you know, the test for liability set forth in Rogers v. Grimaldi has really played an increasingly significant role in trademark-based challenges to the titles and content of creative or expressive works. Although applications of that test vary from court to court, the test generally requires plaintiffs to demonstrate that the infringing work has 1, no artistic relevance to the underlying creative work, or if there is any artistic relevance, the reference is explicitly misleading. A plaintiff before a court that has adopted Rogers must also demonstrate that confusion is likely, whether as a standalone showing, like in the 9th Circuit, or as part of the inquiry into whether the defendant's use of it is explicitly misleading, like in the 2nd. As the Supreme Court held in Jack Daniels, however, Rogers is unavailable if defendant's use of an alleged imitation of a plaintiff's mark is as a designation of source for the defendant's own goods or services, or in other words, if the mark is used as a trademark. So in the wake of Jack Daniels, the Ninth Circuit grudgingly acknowledged the Supreme Court's decision, in this case, Punchbowl v. AJ Press. The plaintiff's mark in that litigation was Punchbowl for online invitations and greeting cards, shown on the left side, when the defendant used Punchbowl News for an online news publication. Defendant there gamely argued that because it was not using plaintiff's mark as a parody, like the Bad Spaniels mark did in Jack Daniels, Rogers still applied. The court was not moved by that contention and explained that the Supreme Court was unequivocal in holding that Rogers does not apply when the challenged use of the mark is as a mark. The Ninth Circuit remanded the case to the district court with this in mind, but did suggest that the expressive nature of the defendant's publication should weigh against a finding of liability. They also suggested that because Punchbowl is a common word, it should be relevant to the likelihood of confusion analysis. Where companies operating in different spaces use the same common words as trademarks with different expressive connotations, the Ninth Circuit said that reduces the likelihood of confusion. So on remand, the defendants actually prevailed, but this time without the Rogers defense. Instead, the court focused on the lack of competitive proximity between the parties' goods and services, with plaintiff selling invitations and Punchbowl offering online news, and less on the basis of the expressive nature of defendant's publication. So I imagine we'll continue to see Jack Daniels and Rogers cases in the coming years in these presentations. Okay, so Rogers was not the only defense that attracted SCOTUS attention in this last year, and the First Amendment was also evaluated in Vidal v. Elster. So without getting too political here, the Elster case arose from an application to register Trump Too Small for various shirts. This phrase came from an exchange between President Trump and Senator Marco Rubio, his now Secretary of State, during a 2016 presidential primary debate, and aims to convey that some features of President Trump and his policies are diminutive, end quote. The USPTO denied registration of this mark under Section 2C of the Lanham Act, which mandates that the refusal of any application to register a mark that consists of or comprises a name identifying a particular living individual without that individual's written consent cannot be registered. So I will just give you all a fair warning that the procedural posture here is ripe with constitutional analysis. So we will try to sum it up as best as we can. And I've set out a timeline here, so it's a little bit easier to follow along. So after the USPTO denied registration, which was upheld by the TTAB, a federal circuit court reversed the decision on the basis that Section 2C had a content discriminatory effect rather than a viewpoint discriminatory effect. That determination, it noted, opened the door to one of two tests for evaluating Section 2C's constitutionality. The first test states that laws that target speech based on its communicative content or content-based laws are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. The second test holds that content-based regulation of commercial speech that does not encourage illegal activity is disfavored, but may be justified if the asserted government interest is substantial, the regulation directly advances that government interest, and the regulation is no more extensive than necessary. The lower court ultimately deemed it unnecessary to decide between the two approaches and instead held that there must be at least a substantial government interest in the restriction of speech. While the USPTO tried to argue that there are two substantial interests at play here, one, the president's state law right of privacy, and two, his right of publicity, the court just found that argument unavailing. With the court rejecting the government's apparent interest in vindicating Trump's rights of publicity and privacy, the court held Section 2C unconstitutional on an as-applied basis, holding that the PTO's refusal to register the mark cannot be sustained because the government does not have a privacy or publicity interest in restricting speech critical of government officials or public figures in the trademark context, at least absent actual malice, which was not alleged here. Following the Federal Circuit's decision, the Supreme Court granted the government's petition for writ of cert, which presented the following question: whether the refusal to register a mark violates the free speech clause of the First Amendment when the mark contains criticism of a government official or public figure. Justice Thomas wrote for the majority and held that as a threshold matter, The Federal Circuit's conclusion is correct that Section 2C, referred throughout the opinion as the names clause, had a content discriminatory effect, but not a viewpoint discriminatory one. Citing the USPTO's practice of refusing registration to applied for marks containing any recognizable references to living individuals, the court explained that the names clause does not facially discriminate against any viewpoint. No matter the message a registrant wants to convey, the names clause prohibits the use of a mark of another person's name without consent. Importantly, it does not matter whether the use of the name is flattering, critical, or neutral. Despite reaching that conclusion, the court did actually not go on to apply one of its traditional frameworks for weighing the constitutionality of content-based restrictions on commercial speech, and instead gave us a historical analysis of trademark law and dove in on trademark law's treatment of claimed rights and personal names in particular. The decision ultimately concluded that several features of trademark law counsel against a per se rule of applying heightened scrutiny to viewpoint neutral but content-based trademark regulations. One such feature the court held was the inherent content-based nature of trademark law, which has never been a cause for constitutional concern. The result of the court's deep dive into the history of trademark law was that the names clause withstood constitutional scrutiny. Essentially, a person generally had a claim only to his name, and one cannot obtain a trademark of another living person's name without consent. The court did note that this decision was narrow. Justice Barrett concurred, but took issue with the court's conclusion that history and tradition settled the issue on the names clause constitutionality and recommended an alternative test for evaluating the constitutionality of restrictions on registrability. She said that content-based criteria for trademark registration do not abridge the right to free speech so long as they reasonably relate to the preservation of the mark owner's goodwill and the prevention of consumer confusion. And a particular restriction would serve those goals if it helped ensure that registered marks actually function as source identifiers. So history and tradition guided us here, and we'll see if the court ever feels compelled to use a firm test on this clause. All right, so for the final section of our presentation, we'll look at a recent 11th Circuit decision evaluating nominative fair use and ease you back into your day from that scary constitutional discussion. This case involves the legendary group Earth, Wind, and Fire. An ex-guitarist of that group joined another band operating under the names Earth, Wind, and Fire Legacy Reunion and the Legacy Reunion of Earth, Wind, and Fire. After a demand by the real Earth, Wind, and Fire, the group changed its name to Legacy Reunion of Earth, Wind, and Fire alumni, but kept a logo similar to that of Earth, Wind, and Fire. So if you see on the slide, we've got the real Earth, Wind, and Fire's logo on the left and the alumni group's logo on the right. And there are definitely some similarities between those two. So in the lawsuit that followed, the defendants argued on summary judgment that their use constituted nominative fair use of the mark and logo of their former employer. For those of you that need a refresher, nominative fair use occurs when the defendant has used the plaintiff's mark to describe the plaintiff's product for the purposes of comparison with the defendant's product. On the other hand, classic fair use occurs where defendant uses plaintiff's mark for purposes of describing defendant's own product. So using apple to describe an apple fruit product. At the time of this case, the 11th Circuit had not yet addressed nominative fair use as a defense and didn't have a test for doing so. So with that, the Florida Federal District Court instead referred to the three-part test articulated in the 9th Circuit's ruling in the New Kids on the Block case. That test considers three elements. First, the product or service in question must be one not readily identifiable without use of the trademark. Second, only so much of the mark or marks may be used as is reasonably necessary to identify the product or service. And third, the user must do nothing that would, in conjunction with the mark, suggest sponsorship or endorsement by the trademark holder. So although the first two factors favored the defendants, the third did not. On the first factor, it is obviously easier to refer to Earth, Wind, and Fire by the name Earth, Wind, and Fire rather than to describe it as the group that sang September, for example. On the second, the court noted that defendants changed their advertising post-complaint, removing the distinctive Phoenix logo shown on the screen, and they would be unable to sell their services without prominent references to Earth, Wind, and Fire. Defendants fell flat, however, on the third element for suggesting sponsorship. Defendants' usage of Legacy Reunion of Earth, Wind, and Fire lacked clear disclaimer or limiting language about who is performing. While there's no explicit claim of sponsorship, the silence was not meaningful. Additionally, defendants combined their advertising with text that discussed the Earth, Wind, and Fire's legacy. Their website stated that the band dominated the 70s with their monster grooves and high-energy danceful hits, garnering 20 Grammy Award nominations and a Hall of Fame induction along the way. So the court held that the marketing and ads were deceptive regardless of whether the defendants' musicians were part of the original band. The use of the word alumni is not enough to dispel the notion that defendants' band is not sponsored by the plaintiff. The court then went through defendants' acquiescence, estoppel, and laches defenses and fully denied their motion for summary judgment. In fact, plaintiff's motion for summary judgment on liability of Lanham Act claims was actually granted. So with that, that'll take us to the end of our presentation. Thank you all so much for joining us. If you have any questions, comments, thoughts, please reach out to Carrie or I here. I've got our contact information on the screen. We'd love to hear from you.
So again, thank you both. Wonderful, wonderful presentation. And Olivia, I think you mentioned some of this you were discussing 2 years ago, and it doesn't seem any more clear now. So
No.
Lovely. I thought trademark law was supposed to be clear. So I really appreciate you taking the time. I know this is volunteer work. I know it takes you away from your day. So from Berkeley, from our listeners, thank you very much.
Thank you so much for having us, Wayne.
Thanks, Wayne.